and I'm doing this out of my office. I was going to see if there's a way that I could get your staff to help me put that up, and then hopefully we could save a little bit of time with me fumbling around with technology.
We'll address that in just a moment.
Yes, sir.
This is CV 2026-013694, Greenleaf Holdings LLC et al. Versus Patel et al. I'll take the appearances for the plaintiffs, please.
Good morning, Your Honor. Greg McGill on behalf of the plaintiffs, Greenleaf Holdings LLC, an Arizona limited liability company, on several direct claims, and derivatively on behalf of GLW Holdings LLC, the plaintiffs. And I'm here with co-counsel Ryan McGill, and my client Dan Coogan is present, observing.
Good morning. I'll take the appearances for the defendants.
Good morning, Your Honor. Jason Koval for the defendants. I'm at the law firm of May, Potenza, Barron, and Gillespie. With me is my associate Trevor Wainfeld, and I believe my associate Matt Adler is going to join me shortly. Thank you.
Good morning. This is the time set for oral argument on the defendant's motion to dismiss. I have reviewed the papers. I've spent a considerable amount of time also reviewing some of the authorities that have been cited, particularly on the claim preclusion issues, as well as the orders issued by Judge McCoy and Judge Julian in the first action, I'll call it, or the 2021 action, I think it is. And I'll probably be addressing some of the issues to try to frame the argument a little bit better when we get to those arguments. It is the defendant's motion. Mr. Koval, I'm going to let you begin. And I think you said you had a PowerPoint presentation. My assistant should be giving you screen sharing abilities if you want to use a PowerPoint.
Thank you, Your Honor. I saw something briefly pop up on my screen and then it disappeared again. I'm not sure if your staff is waiting on me.
Well, you have screen sharing capability, so you probably need to press a button. I can't tell you where it is on your screen that allows you to, there you go. It looks like it's working now.
Perfect. And then I'm just going from slide 1 to slide 2 to make sure that you can see that. That work, Your Honor?
It does. You might want to, it's up to you. I can see all your slides down the left-hand side. You're not in presentation mode, I don't think. It's up to you how you want to present.
Thank you, Your Honor. One moment. Just one moment, Your Honor. Presentation mode is the primary slides. Yes. I've got the judge right here. Okay. So it's these, they're up there in front of the judge, but they're not the primary screen for the judge.
Well, I can see the main slide, the first one that you had there, but I see all your others there too. I just thought you might want it. There you go.
Perfect. All right, Your Honor. What is a slideshow without a little bit of technological difficulty? All right, here we go. We've been in this case, Your Honor, for approximately 5 years with the same plaintiff represented by the same attorney, Mr. McGill. The 2021 case really started in 2014. The plaintiff was lucky enough to win the marijuana license with some partners, and they worked as hard as they could to get it open. They ended up borrowing money from people. They spent it all without being able to open the dispensary. Under the DHS regulations, if you can't open your dispensary, you can lose your license. So Mr. Patel came along and he said, I'm willing to invest. I'm willing to become an owner and an operator, but I'm going to need control. I can't have you guys being able to veto me. And those were the terms of the deal. So in 2014, Mr. Patel purchased a controlling interest in GLW Holdings. He has 75% ownership of that. And then he also has board seats on the license holding entity. And so he's able to control that entity. And ever since that time, this plaintiff has made arguments that Mr. Patel is committing fraud or failing to disclose information to him when Mr. Patel is running his own businesses. And the other thing that's important to note, Your Honor, is in addition to the 2021 case, we've got the 2023 case. So as the 2021 case was pending and we were litigating those issues, many of which are identical to this case, they're the same case, the same fiduciary duty issues, then the lenders come back in 2023 and say that they were never paid back for the money that Mr. Coogan and his former partners borrowed from them. And as a result of that case, the parties entered a settlement agreement, which Mr. Coogan signed with consideration in the hundreds of thousands of dollars to release those claims. So here, one of the very beginning frames that the plaintiff offers is that the defendants are arguing the facts, or that the defendants are not honoring the Rule 12 standard. And we just completely disagree with that. The court doesn't need to accept any of the defendants' characterizations of the facts in order to grant the motion. We're basing everything that we're saying on prior rulings of this court. And so in this court, the Superior Court of Maricopa County, plaintiff tried multiple times to add these very claims into another pending case, and those attempts were denied for various reasons. It was in front of Judge McCoy, it was in front of Judge Julian, and then it was also in front of Judge Julian on a motion for reconsideration. So one of our major points, Your Honor, is that the plaintiff isn't allowed to contradict the Superior Court and call it a well-pled allegation. So when Judge Julian said your claims accrued in 2023, the plaintiffs cannot simply allege that they discovered that same claim in 2024 and prevail on this motion. So that's our starting point, Your Honors. How did we get here? So this plaintiff has offered you inconsistent statements in various forums. This plaintiff is saying diametrically opposing statements. And so all we ask, Your Honor, is, and I know you already have, I'm certain that you've spent a long time looking at this because it was quite complicated and I needed to create a number of charts for myself to see each of the various bases for dismissal of the various claims. And the punchline here is all of the claims fail for multiple overlapping reasons, not always the same reasons, but multiple reasons as to each claim. All right, here, let's start with claim splitting and res judicata. And the reason why we bring these up is because these are dispositive of all claims at the same time. So from a framing perspective, this is the best way for us to go about it. And this idea is that the plaintiff shouldn't be going around and serially filing claims that really relate to the same transactions and events in multiple different courts. So one thought experiment that we have been using in order to conceptualize this issue is the fact that in the 2021 case, the plaintiff filed a special action saying to the Court of Appeals that if it did not reverse Judge Julian and order that amendment was appropriate, well, then he could lose that case and also these specific issues. And so here on the petition for special action, the question is, what would have happened if the plaintiff had succeeded on the special action? Or if the plaintiff goes and petitions to the Supreme Court and then is successful? And the answer is, nothing that's happening in this case would need to go forward because all of those same claims would spring to life in the 2021 case. And so that's the reason why we believe that claim preclusion is the rifle shot that eliminates the entire case. It has three elements, and I'm sure that what we're going to be focusing on is the final judgment on the merits, as the court already previewed. And the focus here is on the same evidence rule. So lawyers are very creative and smart, and they're going to figure out different ways to package the claims. They're going to try to make them seem like they're coming from different parties or that they're actually dressed up as different claims. And the way that the Arizona law works on claim preclusion is that we actually just look at the evidence. So if the claim that needed to be amended in the 2021 case, for example, was an examination of the sale of the Avondale building and whether or not Mr. Patel was enriched by whatever he did there, whether or not the entity was properly defending itself from plaintiff's claims and the lender's claims, well, then all we would need to do is say, all right, how does that compare to the evidence that would be needed for the plaintiff in this case? And the answer is it's exactly the same evidence. These pleadings are the same, but also the evidence for the pleadings is the same. So here's just one quick example where we're looking at the first proposed third amended complaint from the 2021 case, second proposed TAC from the 2021 case, and then this case. And again, the words are the same, but more importantly, the evidence that would go to those words is the same. Here we have, in the 2021 case, a notice of non-party at fault for the entity Balvan, who is being sued here. So currently, right now, in Judge Julian's case, we have oral arguments set on cross motions for summary judgment. Ours is complete summary judgment, theirs is partial, set for August 31st. And in that case, the plaintiff, even though we served this notice of non-party at fault, the plaintiff never brought Balvan in. And the briefing is very similar to the briefing here, where we're talking about whether or not there's any evidence of alter ego or disregard of corporate formalities. There was no discovery on that in the other case because Balvan wasn't named. We're also going to be looking at fiduciary duties. Who owes who a fiduciary duty? And so there's dispositive motions pending in the other case that are almost identical on the words to the issues that are being prosecuted here. So let's get to this final judgment on the merits piece. And we've got these two cases cited here, Your Honor, Bishara, which is an Arizona case, but it's unpublished, and then Professional Management Associates, Inc. versus KPMG, which is the federal case that the Arizona case was citing. And so here, the court would need to adopt the logic and the analysis of Bishara and or Professional Management Associates in order for this argument to prevail. But basically, we are saying Your Honor, can you hear me all right? I don't have your face. Okay, perfect. I just wanted to make sure that I wasn't talking and I'd gotten cut off or something. So on the final judgment on the merits, the court would have to accept the proposition that the denial of the serial motions for leave to amend and the motion for reconsideration below was a, quote, final judgment on the merits.
And here's where you lose me on that argument, and I'll tell you why. It may not matter, and I'll explain that in a moment as well. But I've looked at the cases, the Willow case that you cited, the Bishara case that you cited, and both of those, the decision, the denial of leave to amend in the underlying case clearly was on the merits. There was a finding of futility, or in Willow, there was a finding that there was no indemnification claim, and that's why the claim was futile. And in Bishara, the case there had been removed to the district court. The district court dismissed on the merits, found that there it was time barred. Up on appeal, the Ninth Circuit in the first action affirmed, finding that the proposed amendment was futile. And in the appellate decisions in both of those cases, the two unpublished decisions, the Court of Appeals here found that it was a final judgment on the merits in the underlying actions, the first actions, I should say, because of those findings on the merits of futility, and that was an important decision. I know you cite the professional management associates case, but and the parenthetical for that, and what the Eighth Circuit said in that case. But if you look at that case too said that the district court did not abuse its discretion in denying leave to amend because the amendment would have been futile, and the district court concluded that the Securities Litigation Uniform Standards Act of 1998 also required dismissal. So again, the first action, there was a decision on the merits, and that was important to the Court of Appeals in the second case where it said that claim preclusion applied. And now here's where, and you've cited this case already, and here's where it may not matter. So I think it would, at this point, I think it would be error as a matter of law for me to say that the decisions of Judge McCoy and Judge Julian, her two rulings, were a decision on the merits. I've read those rulings, and those were all based on timeliness, the delay, undue delay, and the pleading standards not complying with Rule 8. It was too lengthy, and the prejudice that resulted from the undue delay. Neither Judge Julian nor Judge McCoy found futility or reached the merits of the claim. I don't think I can find that the denial of leave to amend was a final judgment on the merits. But in the professional management case, they cite Northern Assurance Company of America versus Square D Company, and you've already pointed that out. You've cited that case in the reply, and that really gets into the claim splitting issue, that there's a point to be made on the claim splitting, and as the case, the Second Circuit in Northern Assurance points out, that the denial of leave to amend in the first action really is irrelevant. It's just a proxy for, you know, this claim splitting argument. Under the traditional notions, you have to bring all of your claims at once. So I think that's where the real analysis is. I don't think you're going to convince me that Judge McCoy or Judge Julian made a final judgment on the merits when they denied leave to amend. So I just wanted to throw that out there.
I completely agree with what you said. I think your analysis is right on the money. I mean, when we were going down the road of looking at this and we were evaluating claim splitting and Square D, you know, that your analysis, I think, is correct, Your Honor. And the claim splitting, I think, is really where it comes out, because the element of the prior ruling on the merits, the final judgment on the merits, doesn't apply to claim splitting. And so I'm going to try to persuade you on all the other claims, you know, using these other varying overlapping reasons why they fail. And you know, I guess what I would say is, I think you could do it, but you would have to make a rule. I'm not sure that it's error, but I understand your hesitation to do that. I'm also going to talk about timeliness, not just timeliness within leave to amend, but timeliness with the statute of limitations. And so hopefully I'll be able to persuade you on the remainder of those. But I think your analysis and your read of all those cases is correct, and it's the same as ours. All right, so statute of limitations is the next thing that we try to bring up. 1, 3, 7, 9, and half of 4. 4 is pled as a aiding and abetting two different claims, fiduciary duty and fraud. And that's the reason why we have this strange language about half of 4 appearing in a couple of different places. These are statutes, 2-year statutes on these claims. One moment, Your Honor. Okay, and so this is what we just talked about. This court is looking at this ruling as a non-merits-based ruling. So I'll skip past that. Fraud reliance is the next issue on my slideshow. I think I come back around to statute of limitations in a moment, Your Honor. I'm just jumping slightly out of order because of the conversation that we just had. So the the reliance argument. Here, Your Honor, what we've done is we've identified claims where the plaintiff has pled some kind of fraud. So this is claims 2, 8, and 1/2 of 4, the aiding and abetting fraud. And here, this is kind of a fun, technical, intellectual issue on our side. We've had a lot of fun chatting internally about it. And it's this idea that you could take any tort, like a conversion, and if the argument and the allegation by the plaintiff is that what they're claiming is that it wasn't announced in such a way that the plaintiff wasn't able to intercede and prevent it, well, then it's the quote unquote reliance that the plaintiff is counting on to support its fraud claims. And our argument is that's not cognizably stating a claim for reliance or for fraud. What a fraud is when somebody lies to you. They say, hey, I've got a car right here. It's a 2026 Ferrari with 0 miles on it. Please buy it. And in reliance on that false statement, you purchase it. And then you learn that it's actually a 2020 Toyota with 400,000 miles on it, which you learn because you drove it off the lot and the engine exploded. So that's a fraud. It's when somebody lies or fails to speak when they should, and then the listener reasonably relies upon that and changes position and then suffers harm. And so in the writings, the plaintiff doesn't address this any more than what I've offered here. So perhaps the plaintiff will be able to share with us the solution to that issue. The next thing here, Your Honor, is failure to state a claim. And we can walk through the various claims. If the court has any specific questions about any one of them, I'm happy to address those. Just very, very quickly for accounting, we just think that the plaintiff has a conception of accounting that we don't share. I think the plaintiff is thinking of it as some kind of request for production of documents. And our read on this is that it's an equitable remedy that the court can use in situations where there's some kind of issue with the complexity of different books and ledgers, such that it doesn't really make sense to give it to a lay jury, and that we would use a sophisticated commercial court judge to help us parse through incredibly difficult accounting issues. There's just no allegations that really speak to that kind of accounting claim. Conversion. So here, oddly, there's a couple of things going on. The plaintiff claims that somehow Jay Patel took GLW Holdings money for his own benefit. But really, this is the allegation that somehow money that was being used by GLW to pay its own attorneys and settlement obligations was not okay. And so we don't understand that argument because we think as a matter of law, it's okay for a party to defend itself. And that probably implicates anti-SLAPP considerations. And then separate and apart from that, there's money that GLW receives or doesn't receive hasn't got anything to do with Jay, unless the plaintiff can make additional showings and allegations, which the plaintiff didn't do. So we think that conversion simply fails Rule 8. It just doesn't even plead anything. Declaratory judgment. Okay, this is another issue where we've seen this come up before in other cases. Sometimes what will happen is a party will plead breach of fiduciary duty or breach of contract, but then they'll request declaratory judgment. But instead of saying, you know, the parties have a dispute about contract language, can the court help us? Instead, they'll say, we want the court to declare that there's a breach and that we're owed money damages. And so we cited all the law to the court that talks about why the duplicative claims are inappropriate. And again, we pointed out the inconsistency in some of the defendants' filings here. And that had to do with whether or not GLW Holdings was an ongoing concern, which it is not. It hasn't done any business for a long time and it has no money and it's not operating. All right, fiduciary duty. This is an issue, again, word for word, identical to what's going on in Judge Julian's case, counts 1 and 7. And that has to do with Jay. So the gentleman Jay is an owner and manager of the entity Balvan. Balvan is the manager of GLW Holdings. There is no direct fiduciary duty from Jay to GLW Holdings. Plaintiff can't refute that point. That's the reason why counts 1 and 7 fail. Tortious interference, count 9. We don't understand the expectancy that the plaintiff has alleged. And again, if it's some kind of distribution, there's no pleading that there's an entitlement, there's no legitimate pleading to any entitlement to a distribution under the operating agreement of GLW. And so because of that, we just don't think it states a cognizable claim. Unjust enrichment. So here, this gets back at the linkage or lack of linkage between GLW Holdings and J. And here we're saying that whether or not GLW Holdings made money or didn't make money, it doesn't make sense to say that J was somehow enriched by GLW Holdings receiving or not receiving money. The disconnect between those is that the plaintiff needs to use Valvan and show Valvan. The other thing I would raise for your honor is this claim splitting point and this same evidence, which is this idea that really what we're talking about here, again, is the sale of the Avondale property. And the sale of the Avondale property was, in the lender lawsuit, it was in the 2021 lawsuit, and it was attempted to be added to the case in multiple motions for leave to amend. There is a vague reference to insider loans. That's it. No definitions. So there isn't, some kind of broken out set of facts that we could interpret in other ways. It's just a statement that there's insider loans and there's an implication that Jay shouldn't have given them. But if we go back to where we started, which was the fact that Jay bought into these companies in 2014, he put the money in because the companies were dying. They had none. They didn't even have permitting and they couldn't get open. So yes, he gave it loans. Yes, he got them open and operating, and they're still successfully operating today. And he was paid back loans. There's no claim there. There's nothing wrong with that. And so all of this, Your Honor, is to say that we believe, and we gave you a very detailed and somewhat baroque, but I hope readable roadmap in the conclusion to our reply, where we talked about the various ways that the claims could fail and whether or not it would be with or without leave to amend. And we just have a very short list of claims that we think are even capable of being potentially amended. And honestly, it really depends on what Mr. McGill says right here. So with all of that, Your Honor, is there anything else that I can help you with at the moment?
No, thank you. Let me turn to Mr. McGill.
Thank you.
Okay, thank you, Your Honor. First point I want to make, Your Honor, is the claim splitting.
Hold on one moment, Mr. McGill.
Sure.
We lost defendant's counsel.
Okay, I'll wait.
Let's see if we can get him to join us. Just pause for just one moment.
I assume the clock's not ticking while this is going on.
No, he's rejoining us.
Thank you.
Okay, now you may proceed, Mr. McGill.
Okay, Your Honor, the first point I want to make is that claim splitting argument that you just heard from defense counsel. Nowhere does that appear in the motion to dismiss. That argument was not teed up in the motion to dismiss. It may have been mentioned by Mr. Callahan in the reply, but that's not fair to the plaintiff to raise an issue like that or make an assertion like that in a reply when we don't, as the plaintiff, we don't have an opportunity to respond to that or brief that. So that's an improper assertion at oral argument. It's an improper assertion in a reply that we don't have an opportunity to respond to or to brief. That's number one. Number two, I'm not going to go into the Brashara case in the Willow Creek because you were spot on in your assessment of both of those cases, that neither one of them contained a final judgment or a final adjudication on the merits, which is a central element in res judicata or claim preclusion or issue preclusion. So I'm not going to spend time going over that. And counsel just conceded that your rendition of those cases was correct. Now, they did not concede that it was correct in the reply brief that they submitted, but after you went through it and recited the correct interpretation of those two cases, then they just conceded it at oral argument. In terms of the claim splitting, there's a false predicate that counsel just indicated to you on claim splitting, and this is very important, Your Honor. He intimated that the sale of Avondale was a claim that he's trying to have you believe that the Avondale sale was something that we could have brought when we filed the lawsuit, the underlying lawsuit in 2021. But nothing could be further from the truth, because we were not aware of the sale until, as Judge Julian indicated, July of 2023. So 2 years before our awareness of the Avondale sale is when we filed the underlying lawsuit. So we could not have included the Avondale sale in the original lawsuit in 2021, even if we wanted to, because we were not aware of it. You can't include a claim you're not aware of. So the suggestion by the defense that the Avondale sale should have been part and parcel of the 2021 lawsuit is a false predicate. It's not true. In fact, the sale of Avondale occurred the sale of Avondale without a disclosure of the expenditure of the proceeds to Coogan or Greenleaf occurred during a lawsuit. So it was arguable that we had a fraudulent transfer claim, because in the badges of fraud and fraudulent transfer under the statute, if there is a transfer of a major asset during litigation, one of the badges of fraud is, and there's several badges of fraud which the court is aware of, is that it could conceivably be a fraudulent transfer because it's the sale of the asset and the dissipation of the proceeds without disclosure to the plaintiffs is occurring during the lawsuit, and potentially a fraudulent transfer. We didn't bring that claim we didn't bring a fraudulent transfer claim under the statute in this case, in the 2026 case. But my point is that the sale itself did not even occur until 2023. That's when the sale occurred. So this claim splitting notion is a false predicate, and that should not stop this 2026 action going forward. So let me. I also want to point out, Your Honor, that when you look at the complaint before you in 2026, okay, that complaint has 10 exhibits. There's exhibits 1 through 10, and I presume that you have those or you've had a chance to look at those. I just want to point out that those 10 exhibits are part and parcel of the pleading as well, and I don't want that overlooked. And the third point I want to make is I don't think I need to recite the standards on a motion to dismiss, Your Honor, because I know you're familiar with that, where the court is to restrict its analysis or review, if you will, to the confines of the pleading itself, which is the complaint. And by the way, this complaint, Your Honor, it's well pled. It's clear, it's concise, it's very easy to understand, very straightforward. It's got headings. The reader, there's no confusion, there's no obfuscation, very straightforward. The claims are well pled, the elements are all in there. For example, on fraudulent concealment, reasonable reliance, if you go to allegations 107, 108, 109, reasonable reliance, we have a constructive fraud claim, Your Honor, and we have a fraudulent concealment claim, which is recognized in the Wells Fargo versus Arizona laborers case. When you have a fraudulent concealment by a fiduciary, because Patel worked for Balvan, and that was the fiduciary of GLW Holdings LLC. And when you have a fiduciary, Coogan had a right to rely on the silence from the fiduciary at the time of the sale in 2023. He had a right to rely on a fiduciary who's in a position of trust that they're doing the proper thing, that the proceeds of the sale are being properly secured, that they're not being dissipated, that they're not being diverted for personal benefit, for example. My point is, it was reasonable reliance for Coogan when he's dealing with a fiduciary that the silence during the sale in late 23 and then in early 24, when Ryan McGill sent his demand letter, his inquiry, he made an inquiry, which was proper, before thinking about filing an action. I'll get to the statute of limitations in a second. But on the constructive fraud and the fraudulent concealment, the point is, in allegations 107 through 109, we pled that the plaintiff had a right to rely on fiduciary silence because he's in a position of trust. So he has a right to rely on the fact that if there's silence after a sale, that the fiduciary is properly securing the funds and not dissipating those funds and diverting those funds for self purposes. And that's the reasonable reliance. It was pled. It can be fairly inferred from the pleading. Now, in a motion to dismiss on the standards, as you know, that the allegations in the complaint are deemed to be true. All inferences from those allegations, the court is supposed to read in favor of the plaintiff, not the defendant. And the motion to dismiss, I think, incredulously asked you not only to dismiss the complaint on the pleading, when their motion and the reply presented to you a different version of what happened. A different version of what happened is a refusal by the defense to accept the pleading as true. They're not following the standard. And I'm asking the court, with all due respect to the court, to follow the standard that the pleadings, the allegations are deemed to be true, inferences go the plaintiff's way, and they not only have a different version of what happened, they're saying the proceeds were properly secured, there was no improper expenditures, they were all authorized. You don't have any evidence of that. You just have defense counsel's argument saying that. That's a different version of events. That's Rule 56. That's discovery stuff. That's way outside the pleading. It's way outside Rule 12. They're not entitled to present you with a different version of the events and to try to argue that everything was proper and authorized when the court doesn't know that. That's an evidentiary, it's a conclusory assertion. They're outside Rule 12 and it's not appropriate. The other thing I want to bring up on the standards is that they actually asked you not only to dismiss the case, but dismiss it with prejudice. So let's look at that for a second. First of all, there's a case right on point, Your Honor, and I'm sure you're aware of it. It's called Sunworld Corporation versus Penny Saver, Inc. It's 130 Arizona 585. It's a 1981 case. And in that case, the Court of Appeals held, and it's never been reversed, and the Arizona Supreme Court has never changed this ruling or overruled it, I should say. And in that case, there was a contract claim that was dismissed, but then the Court of Appeals said, but wait a minute, the trial court cannot dismiss with prejudice because the plaintiff has a right to amend the complaint to assert, if it can't assert a contract claim, it can assert an unjust enrichment claim. So it has a right to amend to cure any deficiency. So when the motion to dismiss, but they're asking you to dismiss this case on the pleadings based on a different version of events that gets into discovery and is outside of Rule 12, and they're asking you to dismiss it with prejudice. Defense counsel knows what these standards are. The court we submit would have to, if there's a defect, we don't think there's a defect in the complaint. It's well pled, very clear, very detailed. But if there was a defect, we should have a right to amend, like the Penny Saver case, to cure any defect, and a dismissal on the pleading should not be with prejudice. Okay, I just wanted to go through those standards so I didn't miss that. Going beyond that, Your Honor, Your Honor, assume the complaint is true, which is what Rule 12 requires. A fiduciary secretly sells the company's principal asset. A fiduciary, Patel, who's working for Balvan, and it's a closely held company that he controls. Fiduciary secretly sells GLW Holdings, Inc.'s principal asset, which is the real estate, and it was collecting rent up until then and making distributions to Greenleaf. Okay. Secretly sells the company's principal asset while litigation with a 25% member, which is Greenleaf, is pending. The fiduciary controls the $1 million proceeds, $1.2 million in proceeds, and that fiduciary controls those proceeds. The fiduciary does not account to the member, the 25% member. The fiduciary then uses those proceeds to pay $200,000 for Patel and Balvan, or for Balvan to settle out of the lender suit, the 2023 case, and that was $200,000. And the fiduciary repays himself $500,000 on what we contend to be a phantom loan, because I took Patel's deposition. I asked him for a copy of the note. That's never been produced. In the 2021 case, there's no note evidencing this $500,000 that's in this 2026 lawsuit. I deposed him and asked if interest is being charged. He said no. So there's no note. There's no loan agreement. In the 2021 case, there was no interest charge. So that was a phantom loan. And we believe that was an insider loan. And it was an improper method for Patel, who's acting in a fiduciary capacity, to pull $500,000 out of that $1.2 million sale. Okay. And then we have the attorney's fees, a total of $54,000 that we were able to discover. There may be more. We don't know that because we filed in 2026. We're here now. We haven't gotten into discovery. $54,000 out of that $1.2 million went to pay May Patenda's attorney's fees. And who was the beneficiary of that? That was Jay Patel and Balvan. Okay, because those fees went to pay May Potenza to defend the 2021 lawsuit. So the fiduciary did that as well. And when the member demands the books and records and an explanation of that sale during the 2021 lawsuit, Your Honor, in May of 2024, the fiduciary refuses. Ryan McGill's letter in May of 2024 went through it, and he said that, you know, we want to know where the money went, the distribution of the proceeds, who authorized it, who was the benefactor of these proceeds, because we believe that it was Balvan, because $200,000. Balvan was sued in the lender case. Now, Your Honor, defense counsel also misstated something earlier. He implied that the Avondale sale was part of the lender case. The 2023 lender case was for repayment of investment loans. It was kind of a hybrid. Investment loans were made by a bunch of investors. The Avondale sale had nothing to do with the lender case in 2023. Nothing. Okay? The Avondale sale, it occurred in 2023, 2 years into the 2021 case, and I talked about the claim split. The attorney fee payments in the 2021 case funded Patel, and it funded Arizona Golden Leaf Wellness LLC litigation defense, which was not authorized, and it's self-dealing, and there are conflicts. I mean, there are so many conflicts and breaches of fiduciary duty with Patel's expenditure of the sale proceeds of $1.2 million. And when Ryan McGill sent that letter over in May of 24, Coogan at that time, before that, the sale happened in, I think it was mid-23. In the fourth quarter of 23, Your Honor, and this is on the statute of limitations, Coogan was not in a position to just go file a lawsuit. First of all, he had reasonable reliance. He had a right to rely when he knew about the sale. Your Honor, Judge Julian said that he knew about the sale in July of 2023. He knew about the sale, but he didn't know about the distribution of the sale proceeds or where the money went, or whether it was authorized, or whether Patel benefited from that to the detriment of Greenleaf. That's what he didn't know. And so he did not feel reasonably in the fourth quarter of 23 that he could just file a lawsuit. Because in the fourth quarter of 23, Your Honor, it could have been the case that Patel was on the up and up and he was trying to, maybe he had secured the money. Maybe he was going to do the right thing. Maybe he had not expended, repaid a phantom loan for $500,000. Maybe he didn't use $200,000 of those proceeds to settle Belvan out of a lender case that's totally unrelated, okay, and to the 2021 case. And so it may have been the case in late 23, according to Coogan, that it's on the up and up. There might be a distribution. There may be an adequate explanation. I don't know that. And then in January of 24, that's when the $18,000, the second fee payment, went to May Potenza. We discovered this later in the underlying 2021 case. That was in January of 24. That second payment of $18,000 to May Potenza was in January. Ryan McGill in May is sending his letter to defense counsel saying, making inquiry, which is appropriate, saying, where'd the money go? Who authorized it? Did Patel benefit? Make a disclosure. You're a fiduciary. And what did we get back? Two weeks later, Trevor Wakefield, who's on the camera here today, he sent a letter back citing 29 ARS 2934, I think it was 3404. He cited a statute. He said, you don't have a right to know as a minority member, a 25% member. You don't have a right to know. You don't have a right to disclosure. His letter in May. You don't have a right to disclosure of where the 1.2 million went, even though Greenleaf is a 25% member. It's a minority, has a minority interest, and you don't have a right to know because he cited 29-3404. But that statute, Your Honor, it just says that a member cannot force a distribution unless the company decides to make a distribution. Well, the legislature enacted that because they don't want members forcing management or controlling members to direct a distribution. Okay, that's the statute. But here, that's not what we have. We have the controlling fiduciary. He is not issuing a distribution, but at the same time, he's taking the proceeds and he's paying them to third parties. And for example, on the $500,000 phantom loan that has no evidence or note supporting it, on the $500,000, if that was improper, and discovery will show this, that there's no note, no loan agreement, no interest charge, it's a bogus loan, it's an insider phantom loan that never happened, and it was a methodology for Patel to pull $500,000 out of the sale proceeds, then that's a pretext. That's in a sense, that's a distribution to him, but it's an unlawful distribution. So they're citing a statute. The legislature never said members are not entitled to a distribution, unless management orders a distribution. The legislature did not intend by that statute, well, but a manager can decide not to order a distribution and then secretly abscond with the proceeds of the sale of assets and have phantom loans and take an unlawful distribution to himself. That's not what the statute allows, but that's what they're arguing. Okay, so on the statute of limitations, there was inquiry, and on the statute of limitations, Your Honor, this is very important. The case that goes our way on this, with all due respect, is Walk versus Ring, 202 Arizona 310. And that's where the Arizona Supreme Court, Justice Feldman, went through it. And he said, he held in Walk versus Ring, he held on the statute of limitations. Okay, it's not that you know what happened. For example, the what here is that there was a sale in 2023. In Walk v. Ring, there was a doctor, or I think it was a dentist, that had left some metal in somebody's mouth, and she didn't know whether there was malpractice or not. And Justice Feldman, he ruled that there's two parts to the statute, the accrual analysis on statute of limitations. One is the what and the who. What happened and who did it? But the other is, does the plaintiff know whether there has been a violation of law or that there's been an injury or a harm that's cognizable in court? That's the second part of the test. In 23, we knew there was a sale. We did not know where the money went. We did not know whether it was authorized. We never saw that. And when Ryan McGill asked for that in May of 24, Trevor wrote back and said, and refused to give us anything. So even when we inquired, we got nothing. We got nothing back on that. So that's the accrual, because until that happened, Coogan did not know whether he could file the suit. So that's in May of 24, and we filed on March 31 of 26, which is within the 2-year period. So there is no 2-year statute of limitations bar on these facts and on the law, and based on Walk v. Ring, which is the Arizona Supreme Court. Okay, and I'd like to just briefly go into the complaint itself.
Give me one moment,
Yes.
because we're running out of time, and I have
Sure.
people joining
Thank you.
for our 11 o'clock hearing.
Sure. Okay.
Okay.
Yes. Yes.
Go ahead, but wrap
Thank
up pretty quickly here, Mr. McGill.
Thank you, Your Honor. I appreciate that. Thank you, Your Honor. So I went through the reasonable reliance. That's allegations 107 through 109, and it's rooted in fiduciary silence. That's what it's rooted in, because you're relying on the fiduciary capacity of the defendant, that they're doing the right thing. That's reasonable reliance. And fraudulent concealment is in the Wells Fargo versus Arizona Laborers case. And we have constructive fraud, which is rooted in the breach fiduciary claim. Okay, on the conversion claim, okay, the complaint specifically identifies property. The complaint specifically identified $1,184,590.04 was wired into GLW Holdings bank account on September 2nd, plus the traceable remainder. Then the complaint identifies the alleged acts of wrongful dominion. $500,000 was transferred out in July of 23, plus the identified May Potenza $54,000 in payments that we allege went to May Potenza, Your Honor, if you can believe this, that those payments out of the Avondale sale went to fund the defense of the Coogan underlying lawsuit, and they're not telling him that. They're not disclosing that. So they sold that asset, and Patel sold it, and he used it, the $200,000, to settle his company Balvan out of the lender's suit. He pulled $500,000 out, like I said, with no evidence of a loan, which is a phantom loan, and he's paying tens of thousands of dollars to May Potenza to defend the underlying lawsuit, and not giving Coogan any information on the sale when we're a minority member. And that's what our lawsuit is here. And so that's on the conversion. The issue about whether the operating agreement was in effect, that's subject to discovery, the operating agreement, Your Honor, because there was an issue in the support, Your Honor. There's an operating agreement of GLW Holdings, but it was not signed. Okay, the defense is taking the position, because it was unsigned, that operating agreement should not be applied. But it's a very detailed operating agreement. It was done by the defense. I think it was done by May Potenza. I don't know that for sure. That's just a hunch we have. It's very detailed. It was not executed, but discovery could show that if there was a course of conduct between the parties that were in conformity with the operating agreement, then the operating agreement, even though it's unsigned, could come in as an evidentiary item in a course of dealing, and it could guide the court, because the operating agreement has substantial amount of restrictions on the fiduciary, on Balvan. There are a lot of restrictions on him, what he could do and what he could not do. And importantly, that says that if you sell a major asset out of the ordinary course, which is exactly what happened in Avondale, then that requires a unanimous vote unanimity, and that did not happen. They did not involve the minority interest of 25% Greenleaf. Now, if the operating agreement, because it was not executed, if this does not apply, then you go to the statute, and Your Honor, you go to the statute, which is ARS 29-3408, 29-3409, or it's 29-3409. In that statute, you're aware of that statute, Your Honor. It's the statute that governs LLC standard of conduct for fiduciaries, and it spells it out, and it says fiduciary has a duty of care and a duty of loyalty. And so if the operating agreement is not applied, then you go to the statute. The legislature has filled the gap. You default to the statute. It lays out the manager's duties of loyalty, and it also has a duty to account for any money, and the fiduciary holds it as trustee for the benefit of the company. So we're entitled to discovery over that. That cannot be disposed of on the pleading, on the complaint, for goodness sakes, Your Honor. The last point I want to make is on the attorney's fees. They suggest, well, those were proper. You know, their GLW Holdings has a right to pay attorney's fees. But the key point there, Your Honor, is on ARS 29-3409. That's a provision in the statute. And this is statutory. That's how strong our position is. The legislature says in 29-3409, if there's an advancement of fees or any monies by a member to an LLC, and there's a claim by the member for indemnity or indemnification, which is what they're trying to cloak the fees to the firm and the $500,000. They're trying to cloak it in. These were proper. First of all, whether they're proper is a factual issue, which is outside the complaint. But more importantly, under the statute says if there's an advancement of money or an indemnification, it says that can be done by the company, but it specifically, 3409 specifically refers to 29-3408 or 29-3408 is the indemnification advancement statute. You can have an indemnity or a reimbursement under 29-3408 if it's proper. 29-3408 says that. But 29-3408 specifically ties into 29-3409, which are the standards of conduct for a fiduciary, which says duties of care and duties of loyalty. So if we have breaches of fiduciary duties under 29-3409, the reimbursement and indemnification in advancement of fees or $500,000 under 29-3408 is improper, because 3408 ties to 3409 the fiduciary duties which were breached. They go together. And all of that is dependent on discovery in the case. On the tortious interference, 10 seconds. Tortious interference, Patel interfered with Greenleaf's 25% interest. His conduct interfered with that. So it's not the same contract. We pled it. It's very clear. And we have an unjust enrichment, which is in the alternative to the other claims. Thank you.
Okay. Unfortunately, we are out of time, Mr. Kovalt. Both of you used more than the allotted time, so I'm going to take the matter under advisement. Thank you.
Thank you.